Good morning and welcome to AM News Network presents The Morning Report with Rachel Baird and Ed Peruta. I'm Rachel Baird, that's Ed Peruta. We're here every Monday through Thursday from 7 to 7:30 a.m., transmitting live from the American News Media Center studio here in Harwinton, Connecticut. Please join us as well on Saturdays from 4 to 6 p.m., where we do our flagship show, Summary Judgment, with retired Lieutenant Colonel Matt Tyszkka. Good morning, Ed.
Good morning, Rachel.
Well, yesterday we winded up the show talking about...
Winded or wound?
Winded. Winded,
we winded up the show?
Is that a word? No.
I thought we wound up the show.
Oh, well, that's okay. Wound up the show with curtilage.
Right.
And I said that I might have more information about curtilage today, and I do. I'm going to talk about a Second Circuit case that issued in 2014 called Harris v. O'Hare. And Harris is Glenn Harris, a resident of, or at least in 2006, he was a resident of Enfield Street in Hartford. And O'Hare is an officer who, at least at that time, was an officer. I'm not sure what he's doing now. He may still be an officer. Officer John Michael O'Hare. And John Michael is one word. I found that interesting. So John Michael O'Hare and Anthony Pia, PIA, was the other officer who was sued in this case. Do you want to know more about it, Ed?
Absolutely. Today is August 1st, 2017. It is, the summer is winding down, and hopefully we get some heat before the end.
Okay, this case had as much of a winding history, I dare say, as your case. It started in 2006. The incident was December 20th, 2006, when some officers went to Mr. Harris's house on Enfield Street, and the Second Circuit decision issued in 2014. And then it settled sometime last year, right? Because it made the news last year and it was settling.
And there was a quirky statement made by the city
right
after the settlement. And the quirky statement was this. The city was not going to, said they may not be liable for the damages done by the officers, yada, 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 and, like leaving it on the officers to make the payment.
And this is after years of the city defending the officer, saying, number one, the yard around Mr. Harris's house wasn't subject to Fourth Amendment protection. Number two, even if it was, the officer's actions were reasonable. Number three, there were exigent circumstances. And number four, regardless, they should have gotten qualified immunity. So they argue that through trial. There was a 5-day trial in this case. They argue it on appeal. And then all of a sudden, 8 years later, all of a sudden they say, oh, wait a second, the officer's conduct was such that we're not responsible for it. So it looks like the North End Conditions Unit, the Northeast Conditions Unit, was operating on December 20th, 2006, and we know something about the conditions units in
Officer
Hartford.
Barone was in the conditions unit.
Yeah, and the way they described the conditions unit in this case was, and this is a transcript, a trial transcript, the officers were under orders to get as many guns off the streets as they could. So now we know, basically, what the conditions unit is. Get guns off the street. It doesn't matter how you do it, as you'll see. It doesn't matter if the guns are legal or not. Just get guns off the streets. In other words, in the north end of Hartford, where black people live, get guns away from black people. Right?
Go ahead.
Right. I mean, do we have conditions units in the suburbs where white people own guns? So where there's a collection of black people, you have these units set up to get the guns away from black people at all costs. So they picked up some guy who they knew was out on parole. It looked like he was dealing drugs. They pick up something off the ground around where he is. Turns out to be heroin, so they throw him in the car. Supposedly he gets all nervous. I think this guy's name is Greg Henderson. He gets all nervous. No, George Hemingway. Greg Henderson, George Hemingway. But anyway, his name's George Hemingway. So they throw him in the car, and supposedly he gets all nervous. And all of a sudden he says, I know where there are some guns. In other words, if you have a unit operating in the city that everybody knows the purpose is to get guns off the street, everybody's going to be turning information in about guns to try to get out of trouble,
Let me
right?
go, and I'll tell you where there's a gun.
Okay, I know where there's guns. There's guns at this house on Enfield Street in a car out in the backyard where Mr. Harris lives. Okay, they'd never gotten information from this guy before, but...
Which means he's not a confidential, reliable informant. Go ahead.
So, you know, cutting to the chase, they all go out. Basically, a SWAT team goes out to this location on Enfield Street, and it turns out...
Without a warrant.
Oh, of course, please. A warrant.
Time is of the essence.
Who wants to take the time to get a warrant? They actually use the argument in this case that getting a warrant would have been more intrusive because it would have held up the people and made them wait around. It would have frozen the scene until they got a warrant. And the judge is like, no.
Yeah.
But that's not an excuse.
Put up a perimeter around the property. You know.
So they got there, and there was a fence, a chain link fence around the entire house. It's a single family house with a chain link fence. They just went right through the gate. And there was a dog there. The young girl, the 12-year-old, had just gotten home from school. One of her chores was to take the dog out. They always took the dog out into the yard because it was fenced in. They never put the dog on a leash because it's a fenced-in yard. Officers came through. Dog came out. It was some kind of Saint Bernard, I think. It was a big dog.
It was.
And they shot the dog. Now, there's a couple paragraphs in here about them shooting the dog, and I had to skip over that part of the case. I can't read it. I couldn't read it. So I can't give you details about how that came about. All I know is the dog. Now here's the game that the city of Hartford and these two officers played.
They shot the dog while the 12-year-old girl watched them shoot the dog.
Well, the way they describe it in the case, and again, I didn't read that section, within earshot and near the girl. That's how they describe it.
Okay, go ahead.
Okay. This is the way the appellate court describes how this litigation went. So the defendants, the officers, contended there was no Fourth Amendment intrusion because the entry into the yard was not a Fourth Amendment search. That it was reasonable in any event and that they were entitled to qualified immunity. Those were the three arguments. The district court, both sides filed summary judgment motions. Now, the homeowner, Glenn Harris, and his daughter, maybe other people in the family, I don't know, were represented by an attorney in Eastern Connecticut named John Schoenhorn. I'm going to spell it for you. It's SCHOENHORN of John Schoenhorn and Associates. And, you know, John has been doing these cases for decades. And for him to stick with this case this long, and he does, he sticks with all his cases. When he starts a case from, you know, through the ugliness, through the success, whatever it is, he sticks with cases. And he wins. He wins a fair amount of these very, very difficult cases. And he does criminal defense as well. So, great job, John Schoenhorn, sticking with this case through all of it, and you'll see what I mean. Because he filed a motion for summary judgment, which plaintiffs don't always do. Usually it's the defendant that files a motion for summary judgment.
Saying there's nothing in dispute.
Yeah, and the judge denied both, and the case went to trial. Now get this. Weeks after the pretrial conference, this case is ready to go to trial. The city and the officers say, oh, wait a second, we forgot. We have an affirmative defense of there were exigent circumstances. Oh, we forgot about that for the past, I think it went to trial in 2010. We forgot about that for the past couple years. The judge lets them do it. The judge lets them use that affirmative defense at trial. And
who was the judge?
Judge Shotney. Now, and what was the reason for the exigent circumstances in this case, do you think?
Got to get the guns off the street.
Yeah, that was the exigent circumstances. It's a high crime neighborhood, and we, Illegal guns that are unsecured are a present and immediate danger to the public and to the community. We were going onto that property to take 2 unsecured illegal guns out of the community and into destruction. No arrests, no nothing. So get this, they were not going to that house to make any arrests. They were going to that house to get guns out of a car to take them and destroy them. So many things wrong with that. So many things wrong with that.
Keep talking.
Why aren't black leaders up in arms? Well, I shouldn't say that. Why aren't black leaders
outraged
at the fact that police officers believe that just because you live in the north end of Hartford, they have the right to just come onto your property and take guns away from you?
They're just doing their job.
In other words, black people who live in the north end of Hartford they're not like white people in the suburbs. They can't be trusted with guns. They can't have guns. You know, they're not like white people. It's crazy that black leaders don't get more frustrated with this attitude by the police.
Keep going.
So there was a big argument, obviously, over the jury instructions in this case about how they would be instructed about curtilage, how they would be instructed about exigent circumstances, and lo and behold, there is a verdict for the defense, for the officers, finding exigent circumstances. The jury bought it.
They were doing their job. We got to get those guns out of the black people's neighborhoods.
The jury bought it.
Yeah,
they went right along with it.
And now what was the makeup of the jury? How many white, how many black, how many Hispanic, how many women, how many men?
It doesn't say that in here.
It doesn't say that in there, but I'm going to take a guess that... no, I'm not even going to guess. I'm just going to go like this. If a suburban jury is sitting on this issue, they're going to say, get those goddamn guns out of black people's neighborhood.
Well, I'll just give you a few examples of when I've done jury duty in both state and federal court. If you see a face that isn't white, it captures your attention because it's so freaking out of the ordinary.
Right.
That's just the way it is.
That's the way it is.
Yep. And so, based on my experience, you had a lot of people in this jury who were white, deciding that in the north end of Hartford, the police officers should be able just to go on black people's property and take their guns just because. If a black person who lives in a high crime rate area has a gun, it's an exigent circumstance.
Right, whether it's legal or illegal.
Exactly. Whether they have a permit,
keep going. Keep going.
It's an exigent circumstance. Okay, so this will answer a lot of our questions yesterday about curtilage, because if it's only curtilage if it is property that's protected by the Fourth Amendment. If it's not protected by the Fourth Amendment, it's not curtilage.
Gotcha.
Okay, and we were talking about that the other day. So they addressed the question of curtilage because the plaintiff was upset that the judge did not ask the jury to find in a special interrogatory that they entered the curtilage, that the officers entered the curtilage. But the Second Circuit said, you know what? The jury found that there were exigent circumstances, and so there was no Fourth Amendment violation. So by finding that, they implicitly found that the officers did enter upon the curtilage. Okay? Otherwise,
right. In other words, you don't need exigent circumstances
if it wasn't curtilage.
If there's no curtilage.
Yeah.
So in order for them to, what they did was by arguing exigent circumstances, they admitted curtilage.
Yeah, so the jury did not decide whether the area in question constituted curtilage, but focused directly on whether the officer's intrusion was excused by exigent circumstances. When the district court affirmed the jury verdict on the basis that sufficient evidence existed to support the finding of exigent circumstances, it reinforced the jury's implicit conclusion that the officers had encroached on the curtilage of plaintiff's home.
Right.
Okay, so let's get more to curtilage here. Curtilage questions are resolved with reference to 4 factors. Here we go. Here's the 4 factors. You ready?
Yep.
Number 1, the proximity of the area claimed to be curtilage to the home.
Right.
2, whether the area is included within an enclosure surrounding the home. That's a big one.
Right, because it doesn't define what type of enclosure. Is it a hedgerow of vegetation? Is it a chain link fence? Is it a brick wall? Is it a wooden fence?
A moat.
A moat. There you go.
Number 3, the nature of the uses to which the area is put. You know, do you let your dog out off the leash because there's
Do you have your barbecue grill and picnic table out there?
Right.
Do you have a swimming pool?
When the water company comes to measure how much water you're using, do they have to call first to get permission to come look? Electrical company, those are some other things too. Like when people come onto your property, is it such that they have to get permission to come on because it's not accessible?
Right.
Number 3, did we already do number 3?
What is it?
The nature of the uses to which the area is put.
Yeah.
Number 4, the steps taken by the resident to protect the area from observation by people passing by. Now, a chain link fence like Mr. Harris had on Enfield Street in Hartford, people could see the yard. You know, chain link fence.
Well, did you have to have all 4?
No.
Or some of the 4?
It's a totality of the circumstances, balancing, weighing, you know,
right.
all those kind of things. Okay, so nearly 20 years ago, the Second Circuit concluded that the curtilage of a criminal defendant's home extended to a cottage located 375 feet from the main residence because the entire property was enclosed by a single wire fence, some hedgerows, and woods with no interior fencing separating the cottage from the main residence. So there's just... It really is a circumstance kind of thing. You know what? You know what it sounds like to me? It sounds like it's a question of fact for the jury.
Sounds like Joe Kaminsky's house.
Yeah, it sounds, yeah. And
sounds like Joe Kaminsky's house.
You know, and when I said moat, one of the arguments in Joe Kaminsky's house is one side of the house, the back, faces a lake, Lake Coventry, and that anybody on the lake can see his house. Well, you could also consider that a moat as well.
But from the water line, I'll call it the property beach on Coventry Lake, about 10 feet in, there's a 4-foot stone retaining wall which stops people from being able to just walk onto his property.
Exactly. Fencing and configurations are important factors in determining curtilage. I'm telling you, if somebody were to come to me for advice about how to make it obvious that their property was protected by the Fourth Amendment,
well,
I would say put up a fence.
Let me.
I think fences are.
This sounds like Joe. Those 4 elements sound like Joe Kaminsky's house, but you have to understand something. Aircraft fly over his house regularly and get to see his house. If you have a helicopter, you can see his house.
We have drone footage ourselves.
We have drone footage of his house.
For that NRA video that we're working on.
It's a good piece of evidence for trial.
I was thinking that. Can you find that for me?
Yes.
Good, thanks. The actual use, in this case...
we can show it on TV when I find it.
The actual use of the land includes private activities like cooking. He's got a little grill there and a picnic table.
He does?
Swimming and other intimate activity associated with the sanctity of a home and the privacies of life.
And for all we know, he walks around in his backyard on the lakeside in his underwear or without underwear.
So anybody who's interested in what the end result of this case was, it was reversed. The plaintiff lost the trial. The city of Hartford, then 2 officers won, but the Second Circuit reversed and said because the police officers lacked a warrant or probable cause plus exigent circumstances to invade plaintiff's curtilage, do not invade my curtilage. And because defendants cannot offer any other basis on which the officer's intrusion would be lawful.
Well, let me stop here for a minute.
That the Fourth Amendment
was violated. Let me stop here for a minute, because let's go to Kaminsky. My position has always been when the members of law enforcement learned of a possible situation, they sat around planning how they were going to go about approaching the house.
They actually didn't. I asked Barbara Mattson. They didn't do any plans. They had no contingency.
Trust me when I tell you this. Trust me when I tell you this. They learned of an event, and they had at least a 45-minute drive to the property from headquarters, state police headquarters.
They didn't call Coventry
During that drive, they are thinking what they're going to do. They may have discussed it. We don't know. But they had this time.
Well, Detective Mattson is going to do what she always did. She's going to go up to the house and say, "Give me your guns, or I'm going to arrest you."
Right. Okay. But that was the
plan.
No. But let me tell my theory.
Okay.
Coventry police did come to the house before entry was made into the house. Correct? They were there to provide cover. They were there when entry was made into the house.
I don't agree.
Okay, just hear me out.
That's what they say.
Just hear me out.
No, I'm not going to let you say things that aren't right.
Okay, well then it's not right. You can claim that he gave you permission to come into his house
after you threatened to arrest him.
But the minute you set foot on his fucking curtilage without a warrant, that's when the violation occurs. Forget about going in the house and taking the firearms. You went onto the curtilage and into the area of the curtilage for the purpose of seizing property without a warrant.
Let me get this thought out. If you look at Florida v. Jardines, if you look at that case where they went onto the curtilage with the dog and then the dog smelled the marijuana, and they claimed that smell of the marijuana gave them probable cause to go in. How is that different from Coventry going onto the property and only by virtue of being on the property gaining what they say was consent to go in the house?
Right.
What is the difference?
No, listen to me. In the Florida case, if the dog smelled the marijuana from the public sidewalk.
Absolutely.
But it didn't. They went onto the curtilage.
Or how about this? You got to let me go back and forth because I'm having thoughts. How about this? What if the officers had stood off of Mr. Kaminsky's property and said, "Hey, Joe," or you know what? There's an invention called the telephone. They could have also used that. "Hey, Joe, can we come up there and talk to you?" Yeah, come on up, guys. Why couldn't they have done that?
No problem.
No problem.
Public address system. We've had clients that were sleeping in the middle of the night and a SWAT team surrounds the house and they're announcing for over an hour, flashing big lights through the windows, talking on a bullhorn to get him to come down to the door.
So the only reason the officers didn't do that, they didn't call ahead and they didn't yell from off the property, was because they wanted to be up there at the door in his face where he felt intimidated and he couldn't say no. The same thing as the dog needed to be up on the porch to smell the scent. There's no difference in these cases.
There isn't, because I'm telling you, it was the time frame that they could have gotten a warrant very quickly. It would have been a one-paragraph affidavit to get a warrant. Judge signs it. They go to the house. It would have delayed him by maybe 20 minutes to stop into a courthouse and get a judge to sign it. They show up, they got a warrant. They go onto their curtilage, they go into the house, they don't give a shit. They showed up at the house, which has a row of goddamn pine trees 40 feet high.
We're going to show
you can't see the house.
Drone footage
you
tomorrow.
Can't see the house from the road.
Right.
And we do have drone footage showing the retaining wall on the lake side of the house, and they go like this. You can't see the house. It's enclosed. It's very private. The minute they set foot on his curtilage without a warrant, that's where the violation occurred in the beginning.
Oh.
It got worse as they went closer. you can claim that he invited you into
So-
his house,
so
but
what
how
they're
the
saying-
fuck
what
did
they're-
you get
what
onto
they're
his
saying
property?
Is we may have violated the Fourth Amendment by going onto the. They're not saying this, but I'm saying it. They violated the Fourth Amendment by going onto the curtilage. But once they got up to the door and they say he consented, it wiped away the previous violation.
Right.
But no, you got the consent because of the violation.
Right. Without advising him of his rights. That whatever you, if I ask you a question, can I come in? And you answer yes, that tends to incriminate him.
Yeah, but there's no. Law
I'm just
that says
saying. Look,
this
look.
thing
I'm not
about
a lawyer.
advising
I'm not.
people your
Look,
rights.
look. I'm not a lawyer.
Yeah.
I'm telling you, they had time to get a warrant. This goes back to that thing that I've been saying all along. That in the Nesbitt case, there was no goddamn federal oversight of the seize and then get a warrant. Seize and then get a warrant. I don't believe, based on reading this and all the other shit, that the federal courts are going to put up with what's going on here in Connecticut at the state level. They're going to sit there and say, you can do that on your state level, but you ain't doing that under the federal. No, that ain't happening. I don't believe that this is going to fly.
Yeah, I'm trying to think of a difference.
I don't give three shits. We live in a country, and I'll tell you something. We live in a country that I grew up in, and one of the basic things that I learned before I was a policeman, even growing up, you gotta get a warrant to search or seize. You must have a warrant. Now, I understand exigent circumstances.
If you think about the ramifications of what we're talking about right here, when officers just come to your door, yeah, I mean, look at Chief Riddick from the Waterbury Police Department. 7 or 8 months ago, his advice to the people of Waterbury was, when the police come to your house, don't argue, just let them in. If the police want to search, don't argue. The time to raise those arguments is in court. Chief Riddick, if you consent, then you have waived your right to raise that argument in court.
Right.
You know?
Right.
Worst advice ever from Chief
Get
Riddick.
the fuck away from my door. Get the fuck off my property. Go get a warrant.
In other words, if you don't want to be shot by the Waterbury police, just do what we tell you and then raise the argument in court. Yeah, try that. Try that and see how fast your case is dismissed.
Well, we need to continue this conversation, but not today. We're all done.
Okay, everybody have a great Tuesday. We'll be back tomorrow morning. More curtilage.